Hi, this is Lee from the Law School Toolbox and the Bar Exam Toolbox. Welcome back to part 2 of our 2-part series on strict liability, especially as it relates to animals, both wild and domestic, as well as certain super dangerous activities. But before we get to more hypos, let's dive into a quick review of the law. The basic rule for strict liability for abnormally dangerous activities is: a defendant is strictly liable for damages caused to a plaintiff when engaging in an abnormally dangerous activity. An abnormally dangerous activity is defined as an activity that 1, creates a foreseeable and highly significant risk of harm, even when reasonable care is exercised by all actors, which is 2, not an activity of common usage in the community. So that's the rule to memorize. We need a dangerous activity that is also not common in the community, and based on that activity alone, we can pretty much foresee someone is at risk of getting significantly hurt. But what about animals? With animals, we have a couple more nuances to add to our rules. The first is about wild versus domestic animals. When it comes to domestic animals, the rule is that the owner will not be strictly liable for harm caused unless the owner has knowledge of the animal's vicious propensities. Domestic animals include pets like dogs and cats, although not all pets, as well as farm animals. However, an owner of a wild animal, even if it's a pet, is subject to strict liability for harm caused by the animal, regardless of safety precautions taken by the owner. Animal owners are also strictly liable for trespass and resulting property damage if animals get out and the damage caused is reasonably foreseeable. Now, don't forget that for strict liability to work as a tort, we need to have causation and damages. So now that we're done with that quick review, let's jump into some additional hypos. This hypo is also from the California Bar Exam, this time the torts essay from July 2009. Here are the facts, again modified, so we're focusing just on the strict liability issue. Patty is in the business of transporting human organs for transplant in city. She is paid only upon timely delivery of a viable organ. The delay of an hour can make an organ non-viable. David transports gasoline over long distances in a tank truck. Recently, he was hauling gasoline through city. As David was crossing a bridge in city, his truck skidded on an oily patch and became wedged across the roadway, blocking all traffic in both directions for 2 hours. Patty was delivering a kidney and was on the bridge several cars behind David when the accident occurred. The traffic jam caused Patty to be 2 hours late in making her delivery and made the kidney non-viable. Consequently, she was not paid the $1,000 fee she would have otherwise received. Can Patty sue David for strict liability? Well, let's get right to the first step in our attack plan. Was this an inherently dangerous activity that cannot be made safe? Is driving a tanker truck full of gasoline dangerous? Well, sure, it could explode, it could spill. We even had storage of large quantities of flammable substances as one of our examples we discussed above. So yes, this is probably a dangerous enough activity. Next step, is the activity common to the community? Well, just like our electricity example, gas is one of those things that is in high demand in most communities with cars. That means since there needs to be lots of gasoline to buy, there also needs to be lots of gasoline transported. And the facts say that David was transporting the gas through city, so he is in a place where people probably need gasoline. So again here, while it is dangerous, this activity is also very common. What's another problem here? The facts said that Patty lost the money she would have gotten for transporting a viable kidney on time, since she was late as a result of David's truck blocking traffic on the bridge. Remember, we need to see some kind of foreseeable connection between the type of activity and the harm caused. A truck hauling gasoline could spill gas on the roadway and cause a traffic jam, but that's not what the facts said happened here. It just said David slipped on an oily patch on the road and got wedged sideways on the bridge. Besides spilling and hurting people, gasoline could also ignite and cause an explosion or fire. We also don't have that happening. The harm that happened here is that someone was late in delivering something for their job. That's not the type of harm one would reasonably foresee flowing from the dangerous activity of transporting gasoline. In fact, any other vehicle could have skidded and caused traffic to back up and Patty to lose her sale. This means that just like with the mink case we talked about a minute ago, we also have a problem with the harm not being the right foreseeable type for the dangerous activity in question. So the strict liability claim here could fail because transporting gas is an activity of common usage. It could also fail on causation. Let's look at some examples involving animals. Here's a hypo. Wolf King has a ranch in rural Oregon where he keeps and cares for wolves, which he has raised since they were pups and fully domesticated. Some of the wolves are full-blooded wolves, and others are more typical dog breeds, such as husky, mixed with or descended from actual wild wolves. He calls them all his dogs, and everyone who sees them comments on how tame and docile they are. Wolf King, his employees and guests at the ranch from the surrounding communities often pet and play with the wolves either through the fence of their outdoor enclosure or up close in a state-of-the-art, completely safe indoor viewing area where people can hold and cuddle the wolf pups. Wolf King also has several other species of animals on his ranch, including a herd of sheep and a Chihuahua named Chompy, due to her history of playful biting and nibbling people's fingers. Wolf King, just like everyone in the surrounding county, also has 2 pet boa constrictors. This region of Oregon really loves its pet snakes, and having a boa is even more common than having a cat or dog in this particular region. One day, while feeding the wolves through the bars of a cage, an employee had his hand bitten by a normally calm wolf who happened to be having a bad day. Later that afternoon, a baby wolf scratched the face of a child visitor who was holding it. That night, one boa constrictor escaped its terrarium and climbed into the air conditioning vents in a neighboring home, causing the vents to break. All but 2 of the 50 sheep escaped their pen and tore through the neighbor's prized cabbage patch, eating most of it, as well as blocking the road and causing a traffic jam. Finally, the Chihuahua, who was normally very calm, bit the fingers of Wolf King's friend, who was over for dinner. Can anyone bring a strict liability claim against Wolf King? Well, first off, when it comes to abnormally dangerous activities, keeping wild animals counts. And we know that any harm from the wild animals would probably be the grounds for a strict liability offense. In this hypo, there are a lot of animals, so we want to differentiate between which ones are wild and which are not. What do you think? We've got the pure-blooded wolves, who are absolutely wild animals, even if they've been tamed and raised by humans. The wolves that are merely descendants of wolves, but mixed with other usual dog breeds, are more of a debatable question. The answer would probably depend on exactly how wolf-like they were in terms of their lineage, which could vary, so we'd want to discuss that ambiguity in the facts. The point here is it doesn't matter how tame these animals are. If they're wild, and that probably covers anything other than typical dogs, cats, and farm animals, then you're dealing with a strict liability situation for any owner of those animals. In this hypo, the wolves and the snakes would count as wild animals, even if they're super tame, even if they're considered pets. Any harm those animals did is going to put Wolf King on the hook. Does it matter that the wild animal's pen was safe? No. Does it matter that everyone has wild animals in this town? No. All that matters is that they are wild. So the scratch on the kid's face, the bite to the employee's hand, and the damage to the air vents from the snake would all be recoverable strict liability offenses. What about the sheep that escaped? We know our rule is strict liability for animals that escape and cause property damage. So that would cover the neighbor's eaten cabbages. How about blocking traffic? Well, that's not really property damage, so it doesn't nicely fit our rule. However, it is foreseeable. If a herd of animals gets out and there are roads nearby, it is likely they will get into the road. So this is probably also a strict liability claim if blocking the traffic caused property damage. Finally, let's look at the Chihuahua. Her name is Chompy because she bites people. That sounds like the owner knew about the animal's propensity to bite. On the other hand, the rule requires the owner to have knowledge of the dog's vicious propensities. Nothing about the facts here sound particularly vicious, right? A history of nibbling fingers is not the same as a history of biting people in the face. On the other hand, the guest with the bitten ankle wants to sue, which might mean it was a serious injury. We don't really know, so again, there is some ambiguity in the facts. Plus, this dog does technically have a history of biting. What do you think? The facts are a bit unclear on purpose here. So what you'd want to do is explore all potential avenues. If you think this dog has shown vicious propensities that Wolf King knows about, then this is probably a strict liability offense. More likely, though, this doesn't rise to that level. And that's all we have time for today. Thank you so much for watching. Leave us a like and a comment, and subscribe so you don't miss any future content.